Right, good afternoon, everyone. My name is Christopher Cree. I'm coming to you from our Las Vegas office in Nevada Legal Services. I'm the senior attorney and the Ryan White Part B advocate for the office. So today we're going to talk about the basics of wills and advance directives. So let's just go ahead and get started here. Again, these are the class's basic wills and advance directives. This is just going to be a primer, a quick overview of things. Again, this is brought to you especially by Ryan White Part B and the HIV Impact Programs grants. We assist, if you're not aware of what Ryan White is, it is a program for persons living with HIV, and that so part of that is providing legal assistance for those who qualify. We also have an HIV Impact Grant in Northern Nevada, which also assists people with persons living with HIV with their unique legal issues. All right, so disclaimer here, just so you know, this presentation shouldn't be interpreted as any legal advice because everyone's circumstances are unique. It's intended, like the intent of this presentation is to help you understand wills and advance directives. So when you personally have questions, you're able to ask your attorney the specific questions that related to your case. It shouldn't substitute for like legal advice and it does not create an attorney-client relationship. You should always seek legal advice from an attorney when you're unsure about the law. If you have any questions, feel free to call us or the attorney of your choice to immediately assist you. But we prefer that you come to Nevada Legal Services. All right, so how do you contact us? We're here for you in Northern Nevada. We're located on Marsh Avenue in Reno. The phone number is here, 775-284-3491. We also have a toll-free number as well. We also have a Southern Nevada located office. It's 530 South 6th Street. And our number here is 702-386-0404. And again, if you need be, there is a toll-free number. We'd like for you to follow us on social media. You can find us on Facebook and Instagram at Nevada Legal Services, and also on Twitter at NLS_law. We obviously have a website at nevadalegalservices.org. There's a plethora of legal information there, and you can also do an intake as well if you have a legal issue. And someone will call you back and we'll see if we can assist you with that. And obviously, if you're watching this right now, you know about our YouTube channel. We do these live presentations every second and fourth Thursday of every month, but we also periodically post videos regarding legal issues that we see currently that we get a lot of calls for. And all those videos are archived and available for you to watch. So if you ever have a legal problem that we're not presenting, you may be able to find a summary of the information that you need on there. All right, so let's get started. So today's topics, we're going to talk about the basics of wills, right? What the reasons and benefits to have one, and then what does a will actually contain? And then the second part of this presentation, we're going to discuss living wills and healthcare power of attorneys. These are the types of advance directives if you are incapacitated. So, all right. So, right, I think the first question is why should I want a will, right? A lot of people don't want to deal with it. You know, it's a very touchy subject. Unfortunately, a lot of people do not have them, but these are the reasons, some of the reasons why. First of all, if you don't have a will, your personal property transfers through intestate succession. What that means is, right, the statutes in Nevada lay out how property will be transferred if you don't make your desires known. So usually it's next of kin, usually it could be a spouse or domestic partner. It will depend on the nature of the property and the nature of the relationship with the persons who may inherit. Now, right, and sometimes this can get messy. Sometimes this is what you usually hear about, infighting amongst family members about who gets what, and a will will just, most of the time will deal with this. So, and that gets to the second part, right? Because it does determine who, what, when of your estate. So another important thing, if you do have minor children, you can decide who's going to take care of them. If you don't do this, you leave it up to the dependency court, And it may not always be the person you desire to raise your children. They're good, right? Because the court's evaluation of who's fit and who should raise your minor children if something were to happen to you is not always going to be what you believe is the best for your children. So they do a different analysis. And so if you have someone that you know and trust and is willing to take your children, it's best to just at least have a will to, to express your desire for that. I think another thing that people don't think about is you can actually disinherit people from getting your property. There's a lot, right, especially in the LGBT community, sometimes we're so far removed from our immediate family members for one reason or another. And they, they haven't been around for a while and we just don't have relationships with them. And sometimes you wouldn't want them to take your property. You'd rather have it maybe go to a friend, maybe someone like a life partner, maybe your domestic partner, maybe even like an organization or charity, which gets to the next thing, gifts and donations. So it can wills reflect what you want your property, like your values and interests, right? So maybe, maybe you were homeless for a while and the Salvation Army has helped you. Maybe, the food pantry is somewhere you volunteered and care about. Maybe animals are your cause, right? And so you can give those, make sure that your assets or your things, belongings go to those charities. So you're it reflects what you want and what you desire. And that's really the point of having a will, is so that so there's no second guessing and there's no one there's no second guessing by the court and you don't leave it up to a judge to decide what's best to do with your property. Right. So what's in a will, right? So, it basically it's a testator, which is you, that writes the will. You direct your assets where you want them to be distributed upon death. So the basically elements, in there is it names your heirs, it names your beneficiaries. It usually requires an estate representative. If you do not do this, then what will happen is the court will appoint one. Or, or you leave the burden amongst, your close relatives or family members to sit here and fight about who's going to do it, who desires to do it, who has the time to do it. I just recently had my best friend had a sudden passing of a family member, and amongst her and her 4 sisters, they're still fighting about who is actually going to distribute the assets. And that just delays the process. And I would say now about state representatives. It's if you've never been an executor of an estate, it's not an easy process. And it can sometimes be long and sometimes be very stressful. So it's always appropriate. It's always good to find the person who's willing to do this instead of putting it on a family member who may not may not want to do it or may be too busy to do it. And, it's always difficult when, when someone passes to have to think about those things. I hear a lot of the times, people are asking them to deal with, the person's belongings. And, the person isn't, hasn't even had a proper goodbye or burial or celebration of their life. So it's good to just, for your loved one's sake, to have this available. I think, again, we mentioned this earlier, you can appoint a guardian for your minor children if it's necessary. And again, I just want to emphasize this, someone will have to, the state will, if there's no one identified, the state will intervene for the child's welfare and they will decide, you'll leave it up to a judge and, child services to make this decision. And then also you can appoint a guardian for yourself, for yourself. So, and then, any of these distributions of assets have to go through probate. And so let's move on to what that is really quick. So what is it exactly? It's just a court supervised title transfer of property. There's different types of probate here. I didn't list them because that's really more of an extent, it's a presentation in itself to understand in the state of Nevada. So what I recommend here, obviously, is if you're going through an issue with probate, or you have one in the future about probate, just feel free to call us and we can explain it to you. I don't believe right now we have a presentation on this, specifically, but it may, right, depending on the feedback, I may be willing to do one in the future, just for in the sake of time. There's too much to discuss at this point. So, right. So let's talk about what assets can transfer without probate. So these are assets that are under law or under contract. So examples here, usually the biggest one is the home, right? If you're a married couple and you buy in state of Nevada and you have community property, usually you have to buy it, like, right, both you and your spouse have to be on it. And usually in that, if you look at your documents, it will say right of survivorship by joint tenants with a right of survivorship. What that essentially means is if one your spouse or you passes away, there's no probate that's required. It will just automatically transfer by operation of law to yourself or your surviving spouse. No issue, clean, done with. Since we are in the community property state, all community property has a right of survivorship. Right, so I should probably explain what community property is, because I think sometimes there's confusion on this. So community property is a property that's obtained when someone is officially married. So any property that was obtained prior to marriage, for the most part, is considered separate property. There's a principle called commingling, where you take the asset and you make it in some way community property, but that's, again, community property is a whole other subject. But the basic principle here is that anything that was obtained prior to marriage is separate. So, for example, here I had a case years ago where the person owned a condo in California. It was right, and then married his spouse. They ended up moving to Nevada. He sold the condo and then bought a home in Nevada. And so at that time, if they had, right, and then they ended up being divorced, and then there was a whole argument whether it was community property or not. In that case, it was deemed community property because even though the asset, the condo that was sold and the money from the condo was considered separate, the second he purchased the new home and was married, it became community property. Other things that can be separate property is sometimes inheritances can be considered separate property depending on the nature and how, if it's put in a separate account, if it's put in a joint account, then it's presumed community property. And then also, beneficiaries alive and named and payable on death accounts. So what this is really mostly bank accounts, right? Usually the name of beneficiary to it. The bank will ask you, sometimes they don't, but if you don't have that will either have to be dealt with. And if you don't have that, it will have to go through probate and dealt with in the will, or dealt with in the will through probate or intestate if you don't have one. And then it's the same for the retirement plans, insurance plans, annuities, same thing. Usually there's a beneficiary of those plans. Hopefully you have one. It's always with these beneficiaries, it's always, if you haven't looked at it in a while, this might be a good time to look at it and reevaluate if that's the person you want to be. Maybe, you lost contact with that person. Maybe they passed away. And so it's good to be updated so these things are not subject to conflict later. All right. So sometimes as part of Ryan White, I do get a lot of people who are in domestic partnerships and they get questions about this. I just want to be clear here, in the state of Nevada, registered domestic partners have some of the same rights as married couples, right? So in Nevada, it's community property rights, inheritance rights, hospital visitation, information regarding your partner's medical condition, and medical decision-making. So these are all rights that are afforded by marriage and also afforded to domestic partners. If you're curious about the things that are not, that are granted to married couples and domestic partners, the main one really is the ability to file taxes jointly. Domestic partners on federal taxes are still required to file as single if you are in a domestic partnership rather than jointly. So, but everyone has a reason for domestic partnership, and And so just so you know, like, right, there are some rights, but there are some rights that you may not have. And if you have any questions about that, feel free to reach out to Nevada Legal Services about that. Right, so we're going to get into advanced directives here. So, right, so this is, advanced directives are something that you should have because it's, right, it relates to what happens to your medical care when you can no longer speak for yourself for whatever reason, right? Because how many times have we seen on the news, right, where family members, you know, right, disagree about care, you know, vegetative state, coma. The Terry Schiavo case is always the one I remember. If you guys don't recall that, it's the case from Florida. I can't remember the year. I think it was late 90s, 2000. I'm not, I don't recall, but you know, right. But there was a conflict between the parents and the husband about whether she should stay on a feeding tube or not, even though she had no opportunity. The doctors deemed she would never recover. So, you know, right. And obviously that's in media. We hear these things every once in a while when it becomes a big case. So advanced directives will take care of this mostly, unless somebody in the family challenges your competency to, like, right, your competency to sign the advanced directive. So it's good to, you know, right, to do these sooner or later, especially if you really know, like, right, if you have an idea of what you would want. Right, so two advanced directives include a living will and healthcare power of attorney. Sometimes these documents are together, sometimes they're separate, but either way, it's good to have one. We're good to have both of these. So what's included in a living will? It really describes what medical treatment to request and decline in order to keep you alive. Again, with everybody and health and medical conditions, they're all unique. So, you know, I think it's always, I'm not having any recommendations about what those are going to be or what you should or shouldn't do, obviously. And I think that's a conversation that's more appropriate for between your medical provider and you. But we do recommend you revisit this doc. If you have a document already, we recommend you revisit this from time to time, at least every 10 years, because you're not, you know, it's something sometimes we just put away, we don't think about. Like, right, obviously your health condition could change over time. Maybe it's worse than you, like, right, you have a change of heart, maybe you're better and you would want, right, certain treatments, or, right, so it's good to just kind of have that, like, right, think about that, check on it once in a while, and make sure that everything, the most current living will that you have is really what you want. I think the most common provision is whether you want resuscitation or treatments to prolong life. And again, that's a personal decision that, right, between yourself and your physician, or even, like, right, even if amongst your loved ones, if you have to, but, right, just keep in mind, this is your document, this is what you want, and nobody should influence what your desires are. So, all right. So, right, so let's talk about the healthcare powers of attorney here, right? So what this is about really is ensuring that the person that you want to make medical decisions for you has that power. Now, obviously, the law provides it for spouses, domestic partners, things like that, right? But even in those situations, sometimes you would write, I think it's good to make it clear about who it's going to be and who do you want to make those decisions for you, right? So it's a pretty extensive list of healthcare POA. What it covers, POA, it covers, right, right, consent, right, they basically, like, right, make decisions when you're incapacitated about your treatment, healthcare, right, they can receive information to make that informed decision on your behalf. Obviously, you can direct it here that if there's certain information in there, you would want something done. So that, like, right, so that's very important. And again, like I said, everyone's medical conditions is unique. So, desires about end-of-life treatment. Again, this is very similar to a living will, but it's more, like, right, I think it's more comprehensive. It gives the powers to a specific person to make the call, right? And this can also deal with living arrangements. So if you have to go to long-term care, if you have to go to hospice care, if you want to, you know, right, if you don't want any of that, if you want to, you know, I mean, there's a lot of people who don't want to go to hospice for a variety of reasons. And, right, and that's a perfectly personal choice, right? Some people would rather just be home with friends and family. So, right, and so I think the important key here is to find somebody or identify somebody that you know and trust to respect those wishes, right? Because at that point, right, they're gonna try to make right, they will hopefully try to make the best decision based on what they know about you, who you are, and what they, right, what you've just talked about, and what you would want if it's something you guys have never discussed. Okay, so, all right, right. So even though there's a lot of powers, the powers are limited, right? So, right, they can't commit you, right, to a mental health treatment center. Now, again, this is different from like home treatment or hospice, right? So they can't confine you to mental health treatment. Convoluted treatment, basically shock therapy, essentially. They can't recommend that. They can't send you to that. Psychosurgery, sterilization, abortion, and basically experimental treatments. They can't authorize that. So unfortunately, if you're incapacitated and there's experimental treatment that's promising, but it's not approved, unfortunately, the agent cannot consent to that. And so there's certain people who are ineligible to be agents, right? So, I mean, and then this makes sense, right? Because, sometimes there's a conflict of interest, right? So NRS 162A-840 specifies pretty much healthcare providers. Your healthcare provider, employee of your healthcare provider, operator of a healthcare facility, and employee of a healthcare facility. So basically anybody in the healthcare field. But there is an exception here, right? So if you are if your spouse or domestic partner is, works for one of the, works as a nurse, works as a doctor, works as a, nursing assistant, right? It's just a caregiver facility, they can still make those decisions for you, right? And I think that, because it's presumed that there's not going to be conflict, which, because they're going to presumably do what's best for you. So that should really wrap up our presentation today. Again, I want to end with how to reach us. Again, we have offices in Northern and Southern Nevada. We also have social media, so you can follow us on Facebook, Instagram, and Twitter. Facebook and Instagram, Nevada Legal Services, and Twitter at NLS_law. And then again, our website has a plethora of information, upcoming events, and just updates on the law, right? You can read, we have some blogs there about current, what's going on, what we're seeing. So if you need current legal news, it's there available to you. And of course, we always do YouTube Live on every second and fourth Thursday of the month. So feel free to tune in next month for March for our series. And also, again, all our videos live or otherwise are always archived there. So if you miss something or you realize you have a legal issue and you need just quick summary of what what it entails. Big things for us is housing and unemployment. So if you have questions about that, we have a plethora of videos on there where you can watch and understand. And again, if you feel free to reach out to us on any of our platforms, website, social media, or call us, and we will be willing to help you.